Now, ultimately, the court held the following. Held, Tennessee's law prohibiting certain medical treatments for transgender minor is not subject to heightened scrutiny under the Equal Protection Clause of the 14th Amendment and satisfies rational basis review. Now, since SB 1 is not subject to strict scrutiny, the court affirms the Sixth Circuit's decision, leaving the law in place and unchallenged. The reason behind this decision, though, goes beyond the question of scrutiny. This case carries with it the weight of fierce scientific and policy debates about the safety, efficacy, and propriety of medical treatments in an evolving field. The Equal Protection Clause does not resolve these disagreements. The court's role is not to judge the wisdom, fairness, or logic of SB 1, but only to ensure that the law does not violate the equal protection guarantees. It does not. Questions regarding the law's policy are thus appropriately left to the people, their elected representatives, in the democratic process. I love it when a court stays within its own limits. Contrary to what Justice Sotomayor wrote in her dissent, judging the wisdom, fairness, or logic of the law is outside of the court's purview. That is the job for the elected representatives of the people. Setting aside whether sex transition treatments for children are effective, states may legitimately question whether they are ethical. States have a legitimate interest in protecting the integrity and ethics of the medical profession, which is exactly what Tennessee has done. They have found the use of puberty blockers and hormones to treat gender dysphoria unethical for minors. Beyond that, I believe Justice Thomas made a very important point when he wrote, "This case carries a simple lesson. In politically contentious debates over matters shrouded in scientific uncertainty, courts should not assume that self-described experts are correct. Neither courts, nor anyone else for that matter, should assume the self-described experts are correct. Or as the second pillar of the Constitution study process states, an expert opinion is still only an opinion until there's proof." I only wish more people would learn this lesson.